Good afternoon, everyone. Thank you for joining us for the Federal Employee Defense Services webinar on PLI. Our President, Anthony Vernetti, will be providing you with an overview on professional liability insurance, what is covered in a policy, and why you should be protected. Before we begin the presentation, I do want to make sure that everyone is able to hear me. On the right-hand side of your screen, you'll see a control panel, which will allow you to interact with the presenter. If you can hear me, please click the raised hand on that control panel. Okay, can everybody hear us? Okay, so the presenters will answer questions at the end of the webinar. However, you are welcome to submit your questions throughout the webinar by typing them in the questions chat box. During the Q&A session, Tony will address all of these questions as time permits. If you do have additional questions or think of more later, we will provide you with Tony's contact information so that you can reach out at that time. Please note that the webinar is being recorded. We ask that you please keep your audio on mute until the Q&A open forum to avoid background noise. The recording of this webinar will also be available upon request. At this time, I'd like to turn the presentation over to Anthony Vernetti, President of FEDS.
Thank you, Samantha. Good afternoon, everyone. As Samantha said, I am Tony Vernetti, the President and Founder of FEDS, Federal Employee Defense Services. We certainly appreciate this opportunity to provide all of you with some information about your professional exposures as managers and how a professional liability insurance policy can protect you against those exposures. Definitely going to have to find a way to come down there next time for an in-person presentation. But before we get started, just a little information about my background. I'm an attorney, but let's not hold that against me just yet. More importantly, I'm a former federal employee. I was an attorney for a federal law enforcement agency for several years, and then I worked many years defending federal officials as a partner at my old law firm of Shaw, Bransford, and Roth here in Washington, D.C. So it's my hope today that I can give you a perspective from what I call both sides of the fence, the agency perspective, and then kind of from private practice. I've got a fair amount of material to run through, handful of slides. Usually takes me about 20, 25 minutes, maybe 30 minutes, and then I will open it up for questions, and we'll be happy to stay on, as long as necessary to answer all your questions. So in response to the question, why do I need professional liability insurance? What I typically tell managers is that you need to look no further than today's newspaper or just turn on a TV. Lately, it seems like it's open season on federal employees, whether it's the news outlets, political officials, or other stakeholders. Every single day, you can see examples of hardworking, dedicated, loyal federal civil servants being put under scrutiny. The other thing I kind of tell managers is you're just not going to get through a career as a manager and be doing your job, which is either holding the stakeholders accountable or holding your employees accountable. You're not going to get through a career and not have some complaint filed against you. It's just the cost of doing business these days. And when that happens, you're going to want your own counsel, which is the principal thing that a professional liability insurance policy will provide. Now, for some reason, because the way this video interacts with my Mac, the audio is not working. You can probably hear it in the background here from my computer. But all this is just a series of news stories just to give you a flavor for what I was just talking about. So I'll just move to the next slide. I know this is a briefing about manager liability, and all of you are managers and supervisors, but I did want to briefly highlight some other kinds of positions that have additional, what I call increased exposure. And I do that because if you have like collateral job responsibilities that deal with any of these other responsibilities, It just means like you might have more exposure, or your exposure is going to be increased that much. So anybody working to protect our nation's security or in the intelligence community, ever since 9/11, it's all about national security. So those folks have increased scrutiny. Anybody providing law enforcement or security or first responder services, they also have increased scrutiny. All of you manage or supervise federal employees who may file a complaint against you when you're trying to get a day's work for a day's pay. That's one of the reasons managers and supervisors look to protect themselves with the professional liability insurance policy. This other category, making decisions on public policy or in the interest of the public, I can see that involving some of the work you all do at the Conservation Service there, whether you're working with farmers, ranchers, other landowners, or any of those other stakeholders. Anytime you're making or involving decisions that affect the general public or the public out there or any regulated entity, it could result in increased scrutiny, meaning increased complaints filed against you. Anyone providing medical or financial services, and then sort of any regulated entity, and I can see your group falling into that category as well. This next slide is our first real substantive slide. Liability exposure for federal employees really began back in June of 1971 with a Supreme Court case called Bivens versus 6 unknown narcotic agents, which is the precursor to the Drug Enforcement Administration agency. So it was because of this decision that the Supreme Court first decided that federal employees can actually be held personally liable, even though all their actions were fully within the scope of their employment. So this is not law school. I'm not going to get into what the case does or the legal analysis of it. What I want to emphasize is that this case is what Congress responded to by requiring federal agencies to reimburse managers, supervisors, and law enforcement officers up to 1/2 of the cost of the insurance, okay? So this is significant. Congress understands that you need this protection, and they want to share the burden of the cost with you. This point cannot be emphasized enough because Congress truly appreciates that federal employees in these particular groups need this kind of protection to have peace of mind to do their jobs and know that they will be protected from complaints. So, stated a little bit differently, this is an employee benefit that you should be taking advantage of, okay? No different than taking advantage of the match with the TSP, in my opinion. So professional liability insurance. You want to think of professional liability insurance and your exposures in 3 separate categories. The first, which is the most important for managers and supervisors, is administrative and disciplinary matters. And I will get into that in more detail here in a little bit. The second is civil lawsuits. These are when you are being sued. Now, these are not lawsuits against the government. These are personal capacity lawsuits against you in your personal capacity. And then finally, criminal investigations. So we're going to start with civil suits. So these civil suits are called Bivens actions, which is the name for the case I mentioned earlier, are personal capacity lawsuits, constitutional torts, individual capacity lawsuits, and they generally involve some very, very complicated legal principles. But for today's discussion, I want you to just take away some basic things. Number one is an understanding that you can be sued in your personal capacity for simply doing your job. Number two is DOJ can deny representation, can deny you representation. It is not mandatory. It is not automatic, okay? It's a two-part test. Is it in the interest of the United States to represent you, and were you within the scope of your employment? When justice says it's not in the interest of the United States, when does that typically happen? Well, that happens if you're being investigated, let's say, for some sort of wrongdoing, for the very same reason that you're being sued. You can see that the Department of Justice is not going to want to be on both sides of that, okay? So when you're sued, one of the first things you want to know is who's representing me, right? Now, we always prefer that it's the Department of Justice who represents you, but if they decline to represent you, these are one of the things that a professional liability insurance policy will do, is to provide you your legal representation for you. We will also, in certain cases where Department of Justice is on the fence as to whether they'll represent you, then we may hire what's called coverage counsel to go into the Department of Justice and convince them that it is in the interest of the United States to represent you, because we're always better off when a Department of Justice stands up in court on your behalf. The second major concept that I want you to take away from the civil lawsuit discussion is this concept of immunity. You do not have absolute immunity for these kinds of lawsuits like you do for lawsuits under the Federal Tort Claims Act, okay? You only have what's called qualified immunity, which is still pretty darn good, but what that means is with only qualified immunity, regardless of who's representing you, if they lose and there's a personal judgment against you and the agency refuses to indemnify, it is your pocketbook. It is a financial hit to you personally. So the third concept here is indemnification. You could be held liable for the actual judgment. And these are generally the three areas where professional liability insurance will provide protection. Provides representation, and it will indemnify you if there is an actual judgment against you and your agency refuses to indemnify you yourself. So this is just a fun little slide that we put in here to say, look, being sued or named in a lawsuit is typically a pretty scary thing, as scary as walking into the lion's den, some would say. So you should not walk into the lion's den without your own attorney, is the point here. So quickly, just to recap civil, I want you to take away an understanding that you can be sued. DOJ can deny representation, and you can actually be personally liable for a judgment. And a professional liability insurance policy will protect you in these three major ways. Provides a legal defense, provides coverage counsel. In addition to coverage counsel to convince DOJ to represent you, we will also, in certain cases, particularly significant cases that are noteworthy, getting a lot of media attention, we may appoint coverage counsel to oversee kind of DOJ's representation, of you. Not to kind of get in their way, but just to make sure that your interests, you are insured, are adequately be looked out for. And then finally, the policy obviously pays damages. So that's civil. So for most managers and supervisors, the real value to a professional liability insurance policy and your real exposure falls under what I call the administrative and disciplinary arena. The administrative provision of the policy covers all these kinds of investigations that you see on your screen. So we'll pay for a legal defense up to $200,000 for any administrative matter that could result in a personnel action against you. This is any one of these administrative investigations, so whether it's the Office of Inspector General investigation, Office of Special Counsel investigation, Congressional investigation, any HR or misconduct investigation, EEO, somebody files an EEO matter against you in the agency. So any one of these kinds of investigations, we will provide and appoint you an attorney, what I call cradle to grave, from the start of the investigation up to the conclusion of any investigation, and in the unfortunate event that there's any personnel / disciplinary action taken against you, we will defend both at the agency level and for any appeal that goes to the Merit System Protection Board, which is the administrative tribunal that hears employees appeals for suspensions of 15 days or more, including removals and demotions. So what kind of stuff gets investigated? Really, anything getting significant media attention, or any meaningful, notoriety, and when that happens, there's usually an overwhelming burden on the agency's part to hold people accountable, responsible, and assign blame, regardless of whether the manager did anything intentionally wrong, okay? Regardless of whether the manager did anything intentionally wrong, we have seen an overwhelmingly, burden out there with agencies, wanting to assign blame. And these are just some fun slides that we put together to illustrate this blame game point. So I hope nobody in the audience today is named Johnson. And this final slide is my favorite one. The best way that I know to defend against being made the scapegoat is to have your own legal representative throughout one of these administrative investigations, okay? When the music stops, you want to make sure you're still one of the ones that have a chair. You don't want to be made the scapegoat. And the best way to defend against that is to have your own counsel. So the policy will provide coverage to defend against any allegation of wrongdoing, provided that the allegation arises out of the performance of your job duties, okay? I should make that point. So professional liability insurance has to involve you rendering a professional service. It doesn't cover you if you get in trouble for something that you do off duty, off the clock, not within the scope of your employment. So for one of these investigations, we will provide an attorney to prepare you for the agency investigative process, which is very important. Attend the investigative interview with you if we are permitted. There is not an absolute right to have an attorney with you in the interview, but most investigative entities will allow you that courtesy, and the OIG, which I'll get into in a little bit, certainly does do that. And then ultimately will defend you in any resulting disciplinary action, as I said before, both at the agency administrative level and at the Merit Systems Protection Board. There are 4 types of investigations that I just want to spend a little time on and emphasize. The first is Inspector General investigations. I can't tell you how many times I have heard from my clients or insureds, I didn't do anything wrong, and if I did, I could surely explain. Or if I show up with the lawyer, they'll think I'm guilty. If you are the subject of an OIG investigation, you need to consult with an attorney. If you listen to nothing else I say this afternoon, listen to this. It is important that you understand your rights and obligations when you are the subject of an OIG investigation. Okay, the IG, which obviously the USDA has one, they're assigned to investigate fraud, waste, and abuse and employee misconduct. And believe me, they like making cases against federal officials. The day is long gone where the IGs see it as part of their job to clear federal officials. They want to make cases. And here's another newsflash. They are criminal investigators first. So even though they do their fair share of administrative matters and administrative investigations, they are criminal investigators first. So what does that mean? That means you have constitutional rights. Okay? Most subjects to an IG investigation are very surprised to learn that not every request for an interview from the IG is mandatory. It's compelled. Often, and more often than not, they are a voluntary request for an interview. And submitting to a voluntary request for an interview is essentially a waiver of your Fifth Amendment right, which should never, ever be done without talking to an attorney first. Okay? And if you do talk to the IG, it's very important that you are at least first prepared by an attorney. The next kind of investigation I want to emphasize is the Office of Special Counsel investigations. OSC, or known as OSC, is a quasi-prosecutorial agency that sits here in Washington, D.C., and they investigate prohibited personnel practices. Primarily, they're investigating whistleblower reprisal or some other prohibited personnel practices, such as pre-selections, any kind of violation of the merit principles. So just like the OIGs, they should be taken very seriously. And if you can get legal counsel, you should always get legal counsel and get advice. The reason I want to emphasize the OSC is because they have the authority to prosecute, take action against you independently of your employing agency. And the reason I want to emphasize this is because let's say you're dealing with an employee, one of your employee misconduct matters, okay? And the employee files a whistleblower retaliation complaint against you. Even though everything you did in that case as a manager was with the blessing of your LERD, labor relations, employee relations staff, employee labor relations, or with your Office of General Counsel, and with your management chain, with all the agency PowerPoints, even though everything you did was with their blessing and advice and counsel with them, OSC can still conclude that some sort of wrongdoing happened, that some sort of whistleblower retaliation has occurred, and when that happens and everyone is running for cover, you'll be happy to have your own counsel who is looking out for your interests entirely. Remember, even though your interests and the agency lawyer's interests are typically aligned in these kinds of cases, the client is the agency. That means their duty of loyalty is to the agency and not you personally. The next kind of investigation I want to emphasize are congressional inquiries. Often it is the career federal manager, federal executive that gets served up to testify by the politicals to Congress on a particular matter. And when that happens, you're definitely going to want to have your own counsel there with you. The final kind of investigations I want to cover are EEO complaints. So I'm often asked, why do I need liability protection or my own attorney for an EEO complaint filed naming me as a responsible management official? Isn't it a case against the agency? Aren't the agency attorneys there to defend the EEO complaint and me? While it is true that the agency's attorneys are responsible for defending the EEO complaint and working with you to further the agency's defense of the EEO complaint, again, just like in the OSC scenario, the agency's attorney represent the agency's interests, not yours. This means that the agency, now, to be fair, your interests and the agency's interests are often, very often aligned. I don't want to encourage you not to cooperate and work with the agency attorneys, because you should, okay? But, again, the client's the agency. Their duty of loyalty is to the agency. So it could be a situation where the agency attorney ends up advancing an interest that is adverse to yours. So that's one of the reasons we provide coverage, is we want someone looking out for your interests in that scenario. Also, I have found in my 20 plus years in doing this that managers don't often know what their role is in the process. So if nothing else, having one of our attorneys assigned to you for the EEO investigation, at least we're confident that you're going to get explained to you what your role is in the process, which is to establish what's called the legitimate non-discriminatory reason for doing whatever it is the agency did or did not do in this particular case or complaint. That is the essential evidence that is going to be used later for the agency to defend the case. So we'd like to explain your role in that process. Often, all you know is you get told that somebody's filed a complaint. You usually get angry about that, and the investigator shows up and they want to ask you some questions. Somebody should be there to explain to you your role in the process. So that concludes administrative and disciplinary matters. The final coverage area is criminal investigations. Now, I know most of you did not come to work today intending to commit a federal crime. But as federal officials, you need to appreciate that there is very little you can do wrong in the federal government and not also have it be a violation of Title 18, which is the criminal code. Some of the most common criminal investigations involving a federal manager usually involve conflict of interest statutes, where intent is not a prerequisite to prove the crime, or such things as misappropriation of federal funds, the release of Privacy Act, or other statutorily protected information. Really any situation arising out of an allegation of misuse of your position or authority could result in a criminal investigation. If you are notified that you are the subject of any criminal investigation, it is absolutely imperative and important for you to talk to, and or retain a criminal defense attorney before you talk to anyone. There's an office here in Washington, D.C. within the Department of Justice called the Office of Public Integrity. And they see it as their mission to prosecute federal officials, okay? Even though the underlying thing that is being investigated may be best handled on a purely administrative scale, an administrative matter, or through the misconduct side of the house, they see it as their mission to prosecute federal officials to set an example for the rest of the government, okay? For the rest of the government. Again, if you're the subject of a criminal investigation, you want to seek legal counsel. So those are the three coverage areas. Let's do a recap of what the liability insurance will cover. First, the most important one, I believe, for managers and supervisors are the up to $200,000 in attorney fees for disciplinary matters, which includes investigations, civil lawsuits, so up to $1 million or $2 million to satisfy judgment. You also have that full $1 million and $2 million to use to defend in the lawsuits if DOJ declines to represent you, and then in certain cases we'll have coverage counsel assigned. And then finally, we just talked about the criminal coverage up to $100,000 to defend in a criminal matter. And that's really there to get in there if you are the subject of a criminal investigation to convince the Department of Justice that they do not need to waste their valuable resources prosecuting these matters criminally, that perhaps there's the administrative process can deal with this particular issue. And our attorneys will aggressively seek to what's called get a declination of prosecution. Some other distinctive policy features that I quickly want to mention that are included in our policy. Some of the other policies out there, they do charge extra for that. So the employee practices liability protection, which is when people file EEO complaints against you, or when OSC, whistleblower retaliation complaints, are filed against you, that's included at no additional cost. Some of the other policies out there charge extra for that. Worldwide coverage, covered anywhere in the world, down there in Puerto Rico, that's covered. That's automatically included in our base policy. There are no deductibles. You also get a free 36-month tail of coverage when you leave federal service for civil matters. So that's designed to cover you for the next 3 years after you essentially retire for any civil matter they may follow you into retirement. We also give you 2 free 1/2-hour legal consultations with an attorney for any kind of pre-complaint matters, or anything that maybe is not covered by the core policy provisions, in the master policy. That's an attractive feature that a lot of people have enjoyed. So, affordability. Hopefully, as you can see, it's very affordable. Our base $1 million policy is only $290. $2 million is $390. After the government pays for its half, it's really only $145 annually to you. With hourly rates, for attorneys who are experienced in federal personnel law, running anywhere from $300 to $500 an hour, you can see how the legal fees, even if the allegations are ultimately disproven, you can see how the legal fees, can ratcheted up very quickly. You know, when I was an attorney in private practice, I witnessed people, you know, mortgaging their homes, depleting all their savings, you know, taking out their TSP, you know, because they did not have a PLI policy in place. I used to joke, you know, that I couldn't afford me. You know, I'd just go get a different job, you know, but you've dedicated your career to your profession. You know, you don't have that luxury. You know, truly, the cost of a policy costs less than 1 hour that you're going to spend with an attorney, you know, if you have to hire an attorney on your own. I should also mention here that we do also offer payroll deduction available at $12 a pay period if that's attractive to you. So, you know, in my 20+ years being associated with defending federal officials and a liability insurance policy, I have, you know, struggled with trying to find different ways to emphasize to federal employees the need to buy the insurance. Because the biggest barrier I always come across, that I always see, is that it can never happen to me, all right? The thought that it can never happen to me, all right? You are all hardworking, dedicated civil servants. You didn't become managers and supervisors because you were bad at your job, right? You're not coming to work to do anything wrong. So it's not natural to think that your agency is going to subject you to any investigation. So in struggling with how to respond and deal with that, you know, barrier that I know is out there, you know, I've come up with this analysis, you know, that I think, you know, hopefully it can resonate with you. You can buy the insurance for your entire career as a manager, okay? You're going to spend maybe $5,000, $6,000 for your whole 20, 30-year career, all right? That, and never have to use it, and just have the peace of mind, you know, that you're covered if you need it. That amount of money is not going to change your standard of living when you retire, all right? It's not going to dictate what kind of car that you drive when you retire. But if you get caught having to hire your own counsel for what would have been a covered matter, you know, you better believe it. You got to spend $50,000, $100,000, $200,000 of your own money. It is going to impact your standard of living when you retire. So this is my final slide, and I can't emphasize this final point enough, that you must have the coverage in place prior to the claim or allegation suit happening, or coverage will not apply, okay? I can't tell you how many people are calling us after their house is on fire, right? You can't, you know, get in a car accident on Monday, buy your insurance on Wednesday, think you're going to be covered, you know, on Friday. You know, the time to get your insurance is not after the National Weather Service names the hurricane, all right? You need to have it in place before the allegation is made. You know, there are 3 basic ways to get enrolled. We have a 1-page enrollment form. You can go to the easiest ways is simply go to our website. You know, like I said, it takes less than 5 minutes. You'll answer a handful of questions. You could pay right there by credit card, or you can elect to send in a check, or you can set up your payroll allotment. You're then immediately emailed your certificate of insurance, and then you could take that certificate of insurance and turn it into your agency to reimbursed. The main USDA reimbursement policy is 4060-001, and we can make that available to you after today's webcast. Not sure if your particular conservation service has its own sub policy. They may. I would just search your agency intranet to get access to that. But basically, all you do is you take our reimbursement certificate and you turn it into whoever processes your benefits, and it gets processed just like a travel voucher reimbursement would get reimbursed. So I appreciate everybody's time, and I will open it up for questions at this point.
Hey, Tony.
Yes.
Hi, this is Edwin. I'm the director for NRCS over here in the Caribbean area. Thanks for the presentation. I appreciate Appreciate your time with us. I do have a quick question. You talked about congressional hearings. Are those also, do those apply to state congressional hearings or just federal congressional hearings?
Yes, excellent question. So it would absolutely apply to any state and local, inquiries. So anything, that rises, that's a very good point. I should have made that. You guys obviously have a nexus to working with state and local governments, so you could have, vulnerabilities, there as well as any, if any of you are involved, any professional licensing boards, like for example, lawyers, belong to the state bar, doctors, their boards and things like that, accountants, if there are any professional referrals for those kinds of exposures, those are covered as well.
Yeah, we do have agronomists and engineers that are licensed here in the island.
Yeah, so anything that could affect, their licensing, we would also provide legal representation for, because that's their professional exposure. Think of, this kind of insurance as, the federal employees E&O. So anything that can affect your professional exposure that arises out of your professional responsibilities is going to be covered.
Thank you, Tony.
All right.
Anybody else has a question?
Thanks for your time.
Thank you. Okay. Hey, Tony. That phone number, that's the one where we could contact you?
Yep. And if folks have questions for me personally, you can call. I'm very available. My staff will tell you. My email is just Tony, Tony, @fedsprotection.com. And you can call that number. Anybody who answers the phone, there's no phone bank you go into. Anybody who answers the phone can answer any questions that you have and can get you enrolled. So we're really trying to run a program here that does right by federal employees. With me being a former federal employee myself.
Hey Tony, one quick follow-up question on the congressional local inquiry. Our folks over here speak Spanish at the local government. Is that something that you would handle?
So obviously, if you need a bilingual, attorney, to be able to do that, I mean, that's certainly something that we would factor in.
Great. Okay.
Yeah, I mean that's obviously, yeah. They got to be able to communicate on your behalf.
Yeah. Well, thank you, Tony, very much. I appreciate your time and thanks for connecting with us.
All right, great. You guys have a good rest of the week.
Okay, you too.
Bye.
Thank you. Bye.